but usually the work is done at the Planning and Zoning Commission.
It makes sense. Why make the parties go through it twice? So I kind of get that. All right, thank you.
Thank you. Mr. Balich?
Yeah, I look at this as impeding the public from actually having a voice. I don't understand why I get it. People don't want to sit here for 3 hours like with the Muslim cemetery, with the quarry, with 143rd Street. Well, we took away the right of the people to have all their emails read into the minutes at the full county board meeting, so everybody could hear what they had to say. Now we're talking about removing their right to speak at the county board meeting. Now, despite the time it takes, they have a right to speak at the county board meeting. And what they're going to come in public comment and talk for 3 minutes after we vote? Is that what's going to happen? Or are we just going to say you can't talk anymore? So to me, it's like, it's the wrong thing to do, to remove the right of the people to actually express their feelings, even though there's a lot of them. The more people that come, the more the county board recognizes the fact that there's a problem, because there's a disparity between who is doing what. The county wants this. This is what the people want. So we have to know that. And the more people that come, the more recognizable it is. So I think it's hurting us as county board members from not having a public hearing. So if we remove it, how do you explain that to people that are very frustrated? And you can go through all of them. The people from the Muslim cemetery, the people from 143rd, the people from the quarry, those are the latest ones that we've had. We've had other ones in the past. So they're not going to go away. They're going to keep coming. And I don't want to be, I'm not going to be voting to remove that. But I don't know what the rest of the board will do, because we've already done it in the board level to remove public comments by emails to be read into the minutes. So I don't know what, it's just wrong to me.
Just for clarification, I do believe that the public has an opportunity to speak at the beginning of the meeting for agenda items. So if they are passionate about an item that's on the agenda, they do have the option to speak. I think just they're not able to be cross-examined by the attorneys, the petitioner, et cetera, et cetera. So we're not really taking their voice away.
But that's still a little bit different, because at the public hearing for the actual case, that's one really important.
Okay.
Because like Jackie was bringing up, they ask questions.
Yeah.
We can do a lot of different things at that public hearing. And I think that public hearing is very, very important.
I just don't want the public to think that they don't have the option to speak. They have two different options to speak.
Right, but
One at the
what's
beginning.
going to happen? People are going to feel like they got their right to speak removed if you get rid of the public hearing.
Understood.
Period. So to me, it's totally off limits to do.
And I just want to clarify one last time, to Member Butler's point earlier, when we were talking about they're not acting as judges. When you go into that public hearing, your role changes. You are sitting as a quasi judicial body. You have to make certain decisions based on the things that are in your ordinance and state law. The public comment portion is outside of that hearing. It is not evidence that you can consider as part of the public hearing process. With regards to that, there are due process rights afforded to the landowner. There's, as Joe said, the ability to cross-examine. There are all sorts of things. So those public comments in say a finance scenario, they can be counted in how you vote. You cannot look at those public comments during your decision-making process for a land use case. Only the evidence that is produced in the public hearing. And we do read that warning out every time we have a public hearing, that no new evidence will be introduced outside of the public hearing. So
the question for you then. So during the public hearing, that's what we're supposed to make our decision on. And if we don't hear all the residents talking about what they don't like or what they like, how do we make a proper decision? you would, if it didn't come up in the land use or at planning and zoning, then we don't know it. And a lot of people plan on coming to this stuff. So, I mean, you're kind of like contradicting the whole idea.
I'm not advocating for one position or another. Again, this is not a legal issue for the state attorney's office, other than what I've said is that you're not legally or constitutionally required to have the second hearing. What should happen, if you're making that decision, is that evidence should be produced at the Public and Zoning Commission if you go with this system. That is how that works. I don't know how to deal with your specific issue of that you wanted to bring up a question other than remaining with this system. But as a legal matter, the record would be set at the Public and Zoning Commission.
When you talk about due process, the question I have then, do you mean due process denies the people the right to speak at a public hearing at the full county board that's going to vote?
That's absolutely not what I'm saying.
Well, that's kind of what I'm interpreting. That's why you
The
made it clarify.
landowner has a property right. It is protected by due process, which is why the hearing is done in the Public Zoning Commission or in front of you. That doesn't create a property right or a due process right for the applicants or the objectors to speak outside of that process. They're getting their right at wherever the place is. It doesn't matter whether it's here or at the Public and Zoning Commission. Legally, it has to be at the Public Zoning Commission as a minimum. If you have it here as well, that doesn't affect their rights. They still have a right to speak at the Planning and Zoning Commission.
But all the votes come from here. So if, unless the whole board shows up at planning and zoning, then how do we know what's?
You read the
being
administrative
said?
record. You read the administrative record.
Well,
Okay,
we can go on and on.
yeah, let's give some other members a chance to ask questions, and maybe some of the answers will be presented.